So from today onwards, we are going to start a new series of discussion whereby we will be discussing the test series question papers. Okay, so here we are starting with the polity because it is one of the most important subject, and we are starting with the Sankar IAS. Okay, 2026 test paper. Okay, so let us see the first question. So first question is that with reference to the term republic in the constitution, consider the following statements. It implies statement first. It implies that the head of a state is directly elected for a fixed tenure. Okay, so it implies, so republic means what? That the head of the state should be elected, but whether it is elected on the base on directly or indirectly, there is a difference on that. Okay, for example, in India we have a state of head of the state, as president is the head of a state, and who is elected indirectly. Okay, not direct. So it means that it is incorrect. Okay, so statement one is incorrect. So if we remove one from all of the four options, then we are left with option number B, which is the correct answer. So let us see the explanation as well. It ensures that sovereignty rests with people and do not with any hereditary rule. Yes, that is true. Any hereditary ruler means not means the rule should not be with the king or his son. Okay, hereditary, or his daughter, or anyone, any relative to the king. Okay, now, third one is that it reflects the absence of any privileged class, and the grantees equal access to public offices. Yes, this is correct. There is a absence of any privileged class in India. Article 14, which is equality before law and equal protection of law. Okay, and grantees equal access to public office. Okay, Article 15, there shall be no discrimination on the basis on the ground of religion, race, caste, sex, or place of birth in matters of public employment. Okay, public offices, which is basically means. So B is the correct answer. So let us see the explanation. So a democratic polity can be classified. So a democratic polity can be classified into two categories. Two categories. How many categories? Two categories. Okay. So any democratic polity we can classify any democratic polity into two. First one is the monarchy, and the second one is the republic. In monarchy, what we have in monarchy, the head of a state, usually king or queen, enjoys a hereditary position. Okay, so in the monarchy, what happens that the head of the state, which is your king or queen, for instance, in Britain, they enjoys hereditary position, which means that hereditary means by birth. Okay, so if so after the death of king, who will uh, assume that power of the king, the rule of the state, or they become the head of the state, the son or the daughter of the king. Okay, or the queen. Okay, so it is hereditary. Okay, so that is he comes into office through succession. Okay, through succession. For instance, in Britain. Okay, so you have Britain. Okay, now in a republic, on the other hand, the head of a state is always elected. Okay, directly or indirectly. As I have told you, that in a republic, what happens that the head of the state is elected either directly or indirectly for a fixed period. For instance, in India you have indirect election, and in US you have direct election. Okay, so but both the countries are having head of state as elected. That is why we call them as republic. Okay, now the term republic in our preamble indicates, what it indicates in our preamble indicates that India has an elected head. Okay, called the president. He is elected indirectly for a fixed period of 5 years. So statement one is not correct. Okay, so I have told you, in India we have a president as the head of the state, which is basically indirectly elected. Okay, but here you see in the statement number first that they are saying that the republic means that the head of the state is directly elected. Sorry, for a fixed term. Okay, so what I am trying to say is that the head of the state can be directly elected or indirectly. Okay, so what is certain is that they should be elected for a fixed period of time, but it is not certain that they should be elected directly only or indirectly only. Okay, so both can be happen true. For the context, in the context of India, we have you have the head of the president is the head of the state, who is indirectly elected. Okay, whereas in US, the president is the head of the state who is directly elected. Okay, now republic in Indian constitution vest political sovereignty in the people. Okay, so we know that the republic in the Indian constitution vest political sovereignty in India, because in the preamble, if you see the first line, we the people of India having solemnly resolved to constitute India into a sovereign, socialistic, secular and democratic republic, we call it now. So we are giving that power to, so we the people of India, okay, giving power to the constitution that India should be like this or India should be like that. Okay, which also include republic. Okay, and so it means that republic in Indian constitution vests political sovereignty in the people and not in a single individual like a king. Okay, and the absence of any privileged class, and hence all public offices are open to every citizen without any discrimination, which is basically Article 15. Okay, so let us read it again. So republic in Indian constitution vests political sovereignty in the people and not in a single individual like king, and the absence of any privileged class, and hence all public offices are open to every citizen without any discrimination. Okay, now let us come to the statement number question number 2, which is consider the following: the Comptroller and Auditor General of India provisions related to the oaths or affirmation of which of the above are mentioned under the third schedule of the Constitution of India. So third schedule. So they are talking about the oath and affirmations provisions related to oath and affirmation of which of the above are mentioned under the third schedule of the Constitution. Okay, now what is third schedule? Third schedule, you are having certain office of the certain office, the oath and affirmation of the certain office of the India. Okay, now I don't know basically about this question, so we'll go by the explanation. So they have given a 1 and 2 as the correct. So Comptroller and Auditor General of India, and you have judges of the high courts. Okay, now let us see the explanation. So the third schedule provides forms of oath and affirmation for persons in decision making positions. Okay, so third schedule provides forms of oaths and affirmation for persons in decision making positions, such as ministers, judges. So you have ministers, judges, and auditors. The purpose behind these oaths or affirmations is to ensure that the duties assigned to them are discharged faithfully without any pressure or biases, to maintain secrecy in matters, and to secure that the post is not misused. The third schedule provisions for the oath, for the forms of oath and affirmation, including form of oath form of oath of office for a union minister, form of oath of secrecy for a union minister, oath or affirmation to be made by a candidate for election to the parliament, oath or affirmation to be made by a member of parliament, oath or affirmation to be made by judges of the Supreme Court and Comptroller and Auditor General of India, oath and office for a minister of for a state, oath of secrecy for a minister of a state, oath or affirmation to be made by a candidate for election to the legislature of a state. Okay, so these are the things which are given in a third schedule. Okay, so governors, you don't have that, so 5 has gone. So C, basically you are able to eliminate. 4 is also not there, so D has also gone, and 3 is also not there, so A is the correct answer. Now let us revise it again. So third schedule contains forms of oath and affirmation for persons in decision making positions. Now who are those persons? So we have oath of office for a union minister, oath of office for a union minister. Then we have oath of secrecy for a union minister, oath of secrecy. Okay, so two things you have to keep in mind, that there is a oath of office for a union minister, there is a oath of office for a union minister, and then there is a oath of secrecy for a union minister. Then we have oath or affirmation to be made by a candidate for election to parliament. Oath or affirmation to be made by a candidate for election to the parliament. Okay, so if you are contesting the election to the parliament, then you have to make an oath or affirmation to for that. Okay, then oath or affirmation to be made by a member of parliament. Oath or affirmation to be made by a member of parliament. Oath or affirmation to be made by judges of the Supreme Court and Comptroller and Auditor General of India. Then we have oath or affirmation to be made by the judges of the Supreme Court or Comptroller and Auditor General of India. Then we have oath or affirmation to be made by judges of the Supreme Court, judges of the Supreme Court or Comptroller and Auditor General of India, and Comptroller and Auditor General of India. Then we have oath of office for a minister. For a minister for a state. Then we have oath of office for a minister for a state. Then we have for a minister for a state, we have oath of office for a minister for a state. Then we have oath of a secretary for a minister for a state. Then we have a oath of secretary for a minister for a state. We have a oath of secretary for a minister for a state. For a state. Then we have oath or affirmation to be made by a candidate for the election of the legislature of a state. Oath or affirmation to be made by a candidate for the election of for legislature. Okay, so we have basically oath of office and oath of secrecy for the MLA and MP. Okay, so you have four things: oath or affirmation to be made by MP. Here you have oath of office and oath of secrecy for a MLA. Okay, and oath or affirmation to be made by, sorry, oath of, see, these two and these two are same, common, sorry, not same, common. Oath of office and oath of secrecy for union minister, and here we have oath of office and oath of secretary for a state minister. Okay, then we have oath or affirmation to be made by MP, oath or affirmation to be made uh, by MLA is not there, but election to the MLA. Okay, so election for the MLA. Okay, then election for the MP, and then you have judges of the Supreme Court and Comptroller and Auditor General of India. So these six things. Now let us move forward. Then again we have certain things that form of oath or affirmation to be made by a member of the state legislature. Okay, so state legislature, again the same thing, oath or affirmation state legislature. So MLA, basically oath or affirmation to be made by a member of the state legislature, and then we have oath or affirmation to be made by judges of the High Court. Judges of High Court, thus only the Comptroller and Auditor General of India (CAG) and the judges of the High Courts have their oaths of affirmation mentioned in the third schedule. So option A is the correct. Okay, so option 1 is the correct. Okay, so that is the thing. Now let us see the additional information, because additional information are also very important, because we don't know from where question can be asked. So let us remember. So Article 75.4. Article 75.4. The President administers the oath of office and secrecy to the Union Ministers. Okay, so who administers the oath of office and secrecy to the Union Minister? It is the President. Okay, it is the President who administers. It is a president who administers the oath of office and secrecy of the union minister. The oath of office and secrecy of the union minister. So it is the president who administers the oath of office and the secrecy to the union minister before they handle their charge. They handle their charge. The oath follows the form in the third schedule. Now Article 99. The members of both the houses of parliament take an oath or affirmation before the president. Okay, so before the person or the person appointed by him. So there is a difference, slight difference, that here you see president himself administered the oath of office and secrecy to the union ministers. Okay, but here you have that members of parliament, means MPs of both the houses of parliament take an oath or affirmation before whom? Before president. So that is the minor difference, or a person appointed by him. Now Article 126 124 6, sorry, Article 124 6, Supreme Court judges must take an oath or affirmation before the president. Must take an oath and or affirmation before the president, as prescribed in the third schedule. Now Comptroller and Auditor General of India of India takes an oath or affirmation before the president as per third schedule, Article 148 2. Okay, now next, state minister take an oath of office or and secrecy according to the third schedule before entering office. Before entering office, okay, state minister. Okay, now disqualify Article 84A and 173 disqualify members of central and state legislature if they are not Indian citizens and do not take an oath or affirmation as prescribed by election commission under third schedule. Under third schedule, describe members of central and state legislature if okay disqualify. Sorry. Article 188 members of state legislative assemblies or council take an oath or affirmation before the governor according to members of state legislative assembly or council take an oath or affirmation before the governor according to third schedule. Now, Article 219, judges of the High Court take an oath of affirmation before the governor, as prescribed in the third schedule. Oath of affirmation. So there is a slight difference that judges of the High Court, though the judges of the High Court and the Supreme Court are to be appointed by the Collegium, selected by the Collegium, but appointed by the President. But there is a difference between their oath and affirmation as to who will be before whom they are going to take oath or affirmation. Okay, in case of Supreme Court judges, they are going to take oath before whom, before president. Okay, under Article 124 clause 6, and in under whereas in case of judges of High Court, they are going to take oath or affirmation before the governor as per third schedule under Article 219. Okay, so that is the difference. I hope it is clear now. Now let us understand a few more things. Now question number 3: which of the following provisions were introduced by the Government of India Act 1935? Government of India Act 1935. So this is the, I think, Government of India Act 1935. From here, in last 5 year, one question was there. Okay, so Federation of India, yes, Federation of India was introduced. Then provincial autonomy, yes, that is the correct. Bicameralism in all provinces, Federal Court of India. Federal Court of India, bicameralism in all provinces, I don't think so. Let us see. Let us see the explanation. Okay, so Government of India Act of 1935. Government of India Act of 1935 mark a second milestone, milestone towards a completely responsible government in India. Completely responsible government in India. Government in India. It was a lengthy and detailed document having 321 sections and 10 schedules. It provided for the establishment of an all India federation consisting of provinces and princely states as units. Okay, so it provided for the establishment of an all India federation consisting of provinces and princely states. The act divided the powers between the center and the units in terms of three list: federal list, provincial list, and concurrent list. Okay, now there is a catch. What is catch? That the residuary powers were given to the viceroy. However, the federation never came into being as princely state did not join it. Okay, so that is the thing. Federation never came into existence. So Federation of India. So it is correct. It abolished diarchy. It abolished diarchy in the provinces. And introduced provincial autonomy in its place. And introduced what? Provincial autonomy in its place. The provinces were allowed to act as autonomous units of administration in their defined sphere. So statement number 2 is correct. Okay. Now it introduced bicameralism in 6 out of 7 provinces. Okay, so 6 out of 11 provinces, not in all provinces. Thus, the legislatures of Bengal, Bombay, Madras, Bihar, Assam, and United Provinces were made. Okay, so who were having bicameralism? So it was Bengal, then you have Bombay, then Madras, Bihar, Assam, and United Provinces. Okay, bicameral legislature was there, consisting of legislative council, upper house, and a legislative assembly, lower house. However, many restrictions were placed on them. So statement 3 is not correct. It provided for the establishment of a federal court. Okay, it provided for the establishment of a federal court, which was set up in 1935. Set up in 1935. So statement 4 is correct. Now let us see the additional information. Okay, additional information are always very important. Okay, so let us see. So about the Government of India Act of 1935. Okay, it provided for the adoption of a hierarchy at the center. Consequently, the federal subjects were divided into reserve subject and transfer subject. Okay, so federal subject got divided into reserve subjects and transfer subjects. Okay, and transferred subject. Okay, however, the provision of the act did not come into operation at all. Okay, it further extended the principle of communal representation by providing separate electorates for depressed classes, scheduled caste, women, and labor workers. It abolished the Council of India established by the Government of India Act 1858. The Secretary of State for India was provided with a team of advisors. So Secretary of State for India was provided with a team of advisors. It extended the franchise. About 10% of the total population got the voting right. It provided for the establishment of Reserve Bank of India to control the currency and credit of the country. It provided for the establishment of not only a federal public service commission, but also a provincial public service commission and joint public service commission for two or more provinces. Okay, so that is the thing. Now let us see next. With reference to the Constitution of India, which of the following statement is or are not correct? Is or are not correct? So incorrect basically. The term federation is nowhere used in the Constitution. Yes, this is nowhere. The federation is nowhere used in the Constitution. I think it is not possible. Federation is, I think, somewhere. Yes, it has been somewhere. It has used. I don't know where, but we'll see. The term cabinet is explicitly mentioned in the Constitution. No, cabinet is not mentioned in Constitution. However, cabinet is mentioned in the few legislation. Okay, not in the Constitution. That is correct. See, Constitution Constitution mentions the word Council of Minister and not the cabinet. Okay, now let us see the explanation. So the Constitution of India provides for a federal system of government in the country. The framers of the Constitution adopted the federal system due to two main reasons: the large size of the country and its socio-cultural diversity. Large size of the country and its socio-cultural diversity. They realized that the federal system not only ensures the efficient governance of the country but also reconciles national unity and with regional autonomy. However, the term federation has nowhere been used in the constitution. Instead, Article 1 of the constitution describes India as the union of states. So, oh, sorry. So the statement is not correct. Okay, how many of them are not correct? Okay, so this one is also correct, this one is also correct. Okay, so neither 1 and 2 will be the right answer. Okay, so incorrect, both of them are correct, so it means that D will be the correct answer. According to Dr. V.R. Ambedkar, phrase union of states has been preferred to federation of states to indicate two things. The Indian federalism is not the result of the Indian federalism is not the result of an agreement among the states like the federation, like the American federation, like the American federation. American Federation, sorry, where we were, American Federation. Yes, as the states in India have no right to secede from the federation. The federation is a union because it is indestructible. The Indian federal system is based on the Canadian model and not on American model. The Canadian model differs fundamentally from the American model insofar as it establishes a very strong center. Uh, establishes a very strong center. The term cabinet the term cabinet is explicitly mentioned in the Indian Constitution. The term cabinet is explicitly mentioned in the Indian Constitution. So I was incorrect. It is actually explicitly mentioned in the Indian Constitution. Let us see why. Where? So the cabinet system was inserted in Article 352. It is inserted the cabinet system article 50 by 1977, sorry 90 in 1978 by 44th Constitutional Amendment Act. Okay, so the cabinet system was inserted in Article 352 of the Constitution in 1978 by 44 Constitutional Amendment Act. Now, Article 352 defines the cabinet, saying that it is the council of it is council consisting of prime minister and other ministers of cabinet rank appointed under Article 75 and does not describe its power and functions. In other words, its role in our politico administrative system is based on the conventions of parliamentary government as developed in Britain. Okay, so hence statement 2 is also correct. Okay, so both of them are correct. So the one is incorrect. So D will be the correct answer. Now there are certain additional information. Okay, additional information. So let us see the additional information. Distinction between Council of Ministers and Cabinet. So Council of Ministers. So it is wider body consisting of Council of Ministers. It is wider body consisting of 60 to 70 ministers. Cabinet, it is a smaller body consisting of 15 to 20 ministers. It includes all three categories of ministers. Okay, that is cabinet ministers. You have ministers for of state and you have deputy ministers. It includes the cabinet ministers only. Thus, it is a part of Council of Ministers. Okay, it does not meet as a body to transact government business. It has no collective function. No collective functions. Okay. It meets as a body frequently, usually once a week, to deliberate and make decisions regarding the transaction of government business. Thus, it has a collective functions. It is vested with all powers, but in theory, it exercises in practice the powers of Council of Ministers and the act for the latter. Its functions are determined by the cabinet. Its functions are determined by the cabinet. It supervises it supervises the implementation of its decision by the Council of Ministers. It is a constitutional body. Council of Ministers and dealt with in detail by Article 74 and 75 of the Constitution. It was inserted in Article 352 of the Constitution in 1978 by 44th Constitutional Amendment Act. Okay, it is collectively responsible to the lower house of the parliament. It enforces the collective responsibility of the council of ministers to the lower house of the parliament. Okay, now question number 5. Consider the following. The constitution of India is a mix of flexible and rigid features. Yes, that's it. That is a correct thing. Okay, most provisions of the Indian Constitution can be amended by Parliament itself, whereas a few provisions of the Constitution require both the Parliament and state legislature to act combinedly. That is also true. For amending certain provision of the Constitution, ratification of three-fourths of the state is required. No, this is incorrect. One third is maximum. So both two. No. This is also incorrect. This is also only one of the statement 2 and 3 is correct, and that explain. So that is the 3 is wrong, 2 is correct, and that explain 1. So C is the correct answer. Okay, now let us look at the explanation. Constitutions are also classified into rigid and flexible. Okay, a rigid constitution is one that requires a special procedure for its amendment. For example, the American Constitution demands a special procedure for its amendment. A flexible constitution, on the other hand, is one that can be amended in the same manner as the ordinary laws. The ordinary laws are made. As so, for example, the British Constitution, the Constitution of India, is neither rigid nor flexible, but a synthesis of both. According to Constitution of India, some provisions can be amended by a special majority. According to Constitution of India, some provisions can be amended by a special majority of the parliament, that is two-thirds majority of the members of each house present and voting, and a majority of total membership of the house, which shows the rigid aspect. At the same time, some provisions of the constitution can be amended by a simple majority of the parliament in the manner of an ordinary legislative process. Notably, these amendments do not come under Article 368. This explains the flexible part of the Constitution. So, statement 2 is correct. Okay, and which is and the explanation for A. Statement number 1. Some other provisions can be amended by a special majority of the parliament and with the ratification of half of the state. Okay, half of the states, not three states. Okay, sorry, I was also wrong. I told one third, not half of the states. Okay, still, however, that was still incorrect. Okay, statement 3 is incorrect. Therefore, only one statement is correct. That explains statement number 1. Now, additional information about amendment of the constitution. Okay, let us understand. So, Article 368 in Part 20 of the Constitution deal with the powers of Parliament to amend the Constitution and its procedure. Tested the Parliament may, in exercise of its constituent power, amend by way of addition, variation, or repeal any provision of the Constitution in accordance with the procedure laid down for this purpose. However, the Parliament cannot amend these provisions which form the basic structure of the Constitution. The Supreme Court ruled this in the case Mananda Bharti case 1973. Now, provisions amended under simple majority. A number of provisions in the Constitution can be amended by a simple majority by the two houses of Parliament outside the scope of Article 360. These provisions include admission or establishment of a new state, formation of new states, and alteration of areas, boundaries, and names of existing states. Then you have abolition or creation of legislative councils in states. Second schedule emoluments, alliances, privileges, and so on of the person, governors, and the speakers, judges, etc. Quorum in the parliament. Then salaries and allowances of the members of the parliament procedure later. So these all things you can see. Citizenship. So some are important: citizenship, acquisition, and termination. Okay. Then election to the parliament and state legislature, delimitation of constituencies, union territories, fifth and sixth schedule. Okay, so these can be done by simple majority. Okay, conferment of more jurisdiction on the Supreme Court, number of few signed judges in the Supreme Court, then use of English language in the Parliament, use of official language. Okay, then we have privilege of Parliament and its members and its committees, rules of procedure in Parliament, salaries and allowances of the members of the Parliament. Okay. Now, question number six. Consider the following statement: right to disconnect is recognized as fundamental right under Article 21 of the Constitution of India. So I remember this is basically this question is taken from the one of the very fine article written by Dr. Sasi Tharu sir, which was basically right to disconnect in the Hindu. Okay, I think last month or early this month only this wonderful piece was published. Okay, so right to disconnect is not recognized till date a fundamental right, but there is a demand of giving recognition status to right to disconnect as fundamental rights under Article 21. Okay, so this is incorrect. Okay, so if you can see the statement number 1 is incorrect, so D will be the correct answer. Okay, now let us see statement number 2. It allows employees to disconnect from their employer outside of working hours. So this is a correct thing. Okay, so right to disconnect is simply that there should be a fundamental rights where an employer cannot contact or send any information communication after working hours to the employee. Okay, for example, you see you know that after working hours ends, what happens that the employer sends email or the communication informing his employee that this work has to be done, this task has to be done within this time frame. Okay, so that kind of thing is happening. That is why there's a demand of right to disconnect. Okay, so that is the thing. So let us see the explanation. Okay, so let us see the explanation. Okay, so the right to disconnect is a novel initiative aimed at elevating the pressures of work after official hours. Okay, elevating the pressure of work after official hours. Right to disconnect laws allow employees to disconnect from their employees outside of working hours. Outside of working hours, employees can decline work related communication outside of regular hours without facing negative consequences. Okay, it includes not being obligated to monitor, read, or respond to work emails, phone calls. Yes, I have told you emails, text messages, or other forms of communication once their work day has officially ended. So, statement 2 is correct. The right to disconnect is not recognized as a fundamental right under Article 21 of the Indian Constitution. Okay, India does not have a specific laws recognizing the right to disconnect from work. However, the Constitution, the directive principle of a state policy, and various judicial pronouncements had spoken of the right to work in a conducive and healthy environment. Okay, now Article 38 of the Constitution mandates what it mandates, that the state shall strive to promote the welfare of the people. Again, Article 39B of the directive principle of a state policy directs the state to direct its policy towards securing the strength and health of its workers. Okay, so statement one is hence statement one is incorrect. Okay, now we need to have certain additional information. Okay, now, recently in news, status of right to disconnect law in India and various countries. Okay, so status of right to disconnect law in India and various countries. Okay, now recently in news, Australia's new right to disconnect law highlighted the need for better work-life balance in India. So Australia has introduced the right to disconnect. Okay, which has led to the demand in India to have better work-life balance. Okay, where workplace stress is high. So India we have workplace stress which is very high. The issue gained more attention after the death of young EY employee in Pune, and a mixed opinions from the industry leaders on how much work is too much. Now let us see the India's perspective. India does not have a specific law on the right to disconnect. Okay. However, the constitution and courts have recognized related rights about dignity, health, and safe work environment. Now, judicial aspects. So let us see the judicial aspect. So in the Bisakha versus State of Rajasthan 1997, sexual harassment at the workplace violates the fundamental rights, recognize the right to dignity and safe working conditions. Okay, now there was another case which is popularly known as Ravindra Kumar Dhariwal versus Union of India 2021. Equality includes accommodating employees, disabilities, and individual differences. Okay, Justice D.Y. Chandrachu's views. Okay, now Parveen Pradhan versus State of Uttarakhand 2012. Superiors cannot humiliate or scold subordinates mainly in front of others. Okay, now let us see certain developments with regard to right to disconnect. So in France, as early as in 2017, what happens that the companies with 50 or more employees must negotiate guidelines allowing workers to disconnect from emails and other work related communication after working hours. Okay, so it is mandatory for the companies who are with 50 or more employees, that they should negotiate guidelines which will allow workers to disconnect from emails and other work related communication after working hours. In the same year, Italy has also made a provision whereby employees have the right to disconnect during rest period. Employees have the right to disconnect during rest periods, especially under remote working arrangements. Okay, now again, Spain 2018. The law is enacted as a part of Data Protection and Digital Rights Act law, 2018. It mandates employers to develop policies on the right to disconnect. Now Ireland 2021 introduced a code of practice in 2021 which protects employees from penalization for not being able to available after hours. Okay, after hours. Now Belgium 2022 It promotes mental well-being and work-life balance. Initially enforced for federal civil servants, with a similar push for private employee sector employees as well. Now, recent development is the Australia 2024. The law allows employees to ignore communication after hours if they choose to. Okay, without fear of being punished. Okay, so that is the thing. Now, just we need to have certain idea about which are the countries where it is legal. Okay, right to disconnect is accepted. Okay, or legalized. Okay, so these are the countries. France, you have France 2017, you have Italy, you have Spain, you have Ireland, you have Belgium, and recent is the Australia. Okay, so recent three we need to remember. So Australia, Belgium, Ireland. Okay, Australia, Belgium, Ireland. Australia, Belgium, Ireland. Australia, Belgium, Ireland, Spain, Italy, France. Okay, so with me, please speak at least 5 times. Okay, please read out all these things at least 5 times, and the name of the country. Okay, so let us start. Australia is there, Belgium is there, Ireland is there, Spain is there, Italy is there, France is there. Australia is there, Belgium is there, Ireland is there, Spain is there, Italy is there, France is there. Okay, Australia is there, Belgium is there, Italy is there, Spain is there, France is there. Okay, Australia is there, Belgium is there, Ireland is there, Spain is there, Italy is there, France is there. Australia is there, Ireland is there, Italy is there, France is there, Belgium is there, Spain is there. Australia, Belgium, France, Italy, Ireland, Spain. Okay, I hope that remember two, at least two, France and Australia. France and Australia. Though questions are this question may not, most likely there will be no question this year on this topic, but we can't know, we can't expect any. We can't have anything called certain in UPSC. Okay, examination. Okay, so remember France, Italy, Ireland, Australia, Belgium, and Spain. Okay, now moving to the next question, which is question number 7. In the preamble of the constitution, liberty is provided for how many of the following? Okay, so basic question, very basic question. So preamble, liberty is provided for how many? Liberty of thought, expression, belief, faith, and worship, all of them. So all of them are correct. Okay, liberty of thought, you have liberty of thought, expression, belief, faith, worship. Okay, all of them. Now let us see the explanation. Okay, the term preamble refers, what is preamble? So it is basically the introduction or preface to the constitution. Okay, it contains the summary or essence of the constitution. It contains what? The summary or the essence of the constitution. The preamble to the Indian constitution is based on the objective resolution which was drafted by Pandit Jawaharlal Nehru, adopted by the Constituent Assembly. Okay, okay, it has been amended by 42nd Constitution Amendment Act 1976, which added three new words, which are socialist, secular, and integrity. Key terms in preamble are sovereign, then you have secular, then you have socialist, then you have democratic, then you have republic, justice, liberty, equality, and fraternity. Term liberty means the absence of restraint on the activities of individual, and at the same time providing opportunities for development of individual personality. Okay, now what is the meaning of the liberty? So the term liberty means the absence of restraints on the activities of individuals, and at the same time providing opportunities for the development of individual personalities. Okay, so two things you have to remember, two things, that there should be absence of restraints on the activities of the individual. Okay, absence of what? Absence of restraints on on the activities of the individuals, as well as at the same time providing opportunities for the development of individual personalities. Okay, the preamble secures to all citizens of India. So all citizens of India liberty of thought, expression, belief, faith, and worship through their fundamental rights enforceable in the court of law in case of violation. Okay, liberty as elaborated in the parliament is essential for the successful functioning of the Indian democratic system. However, liberty does not mean license to do what one likes, and has to be enjoyed within the limitation mentioned in the constitution itself. In brief, the liberty conceived as a parliament of fundamental rights is not absolute but qualified. Okay, so that is the correct thing, because there can be, it is never restriction placed by the parliament, okay, by law. Now preamble or any in under any extraordinary circumstances, for instance the emergency provision. Okay, now preamble of the constitution. About the preamble of the Indian constitution highlights four key aspects. Okay, it is stated that the source of authority of the constitution lies with the people. Okay, so what is the source of authority of the constitution? It is the people of India. It declares the nature of the Indian state. So, nature of Indian state is what? Sovereign, socialistic, secular, democratic, and republican. It outlines the objective of the constitution. So, objectives are what? Objectives are justice, liberty, equality, and fraternity. Specify the date of adoption as 26 November 1949. Now, key features. So, what are the key features? The preamble of Indian Constitution describes India as the sovereign, socialistic, secular, democratic, and republican state. Okay. Now, what is the meaning of sovereign? So, sovereign means India is fully independent. India is fully independent. It has supreme power. Okay, so sovereign means that no external force can influence the decision of India. Okay, India is fully independent to take its own decision. It has supreme power with no authority above it, and it has its sovereignty is expressed through parliament, which represent the will of the people. Okay, which represents what? The will of the people. Socialist were added in 1976 by 42nd Amendment. It reflects the aim of reducing inequality and working of the welfare of the citizen. Secular means the state does not favor any religion. Instead, it treats all religions equally to maintain peace and harmony in diverse society. Democratic means people rule through elected representatives. In India, democracy is not just political but also includes social and economic aspects, ensuring equality and justice. Now, republic means India has an elected head of a state. Okay, republic means India has a elected head of a state chosen for 5 years, not hereditary ruler. It also ensures that the sovereignty rests with the people, and no special privileges exist. No special privilege exists. Everyone is equal before the law and eligible for public office. Okay, so two more question we will be doing. Okay, now which of the following is are correct regarding the bill introduced for the purpose of altering boundaries of the state? Okay, which of the following is correct regarding the bill introduced for the purpose of altering the boundaries of a state? So it is basically simple majority. Okay, it can be introduced only in the house of the people. No, this is incorrect. It requires prior recommendation of the president. I don't know. It should be passed by a special majority. I know that this is incorrect. Okay, so 3 is basically incorrect. I also know that 1 is also incorrect. So A could not be the correct answer. C could not be. D could not be. So B is left. So B is the correct answer. Okay. So I don't, on the basis of knowledge, I don't have answer, but by using elimination technique, I know that the answer will be B. However, I don't know that the it requires the prior recommendation of the president. Purpose of altering boundaries of any state. Let us explore the explanation section. Okay. Now you see Article 3. Okay, we have Article 3 of the Constitution of India. Article 3 of the Constitution of India gives Parliament the power to form new states, or change the area, boundary, or name of existing state. Okay, so Article 3 of the Constitution of India provides Parliament the power to form the Article 3 of the Constitution of India provides the Parliament the power to form a new states, change the area, boundary, or name of existing state. A bill for this purpose can be introduced in either of house. Okay, either house of the parliament can be introduced in either house of the parliament, but only with the president's recommendation. Okay, so president's recommendation is important. If the bill affects a state, the person must send it to the state legislature. If the bill affects the states, okay, the person must send it to the state legislature for its opinion within fixed time. Okay, the views of the state legislature are not binding. Views of a state legislature are not binding. Parliament may accept or reject them. If the bill is amended in the parliament, it is not necessary to send it back to the state legislature. For Union territories, no reference to their legislature is required. Parliament can decide directly. Okay, so statement number one is not correct. Statement two is correct. Okay, so one is not correct. I told you it is incorrect. Two, I don't know, but three, I know that it is incorrect. Okay, so to that is how I got B is the correct. Now see, the Constitution of India under Article 4 declares that the laws made for the admission or establishment of new states, and Article 2 and formation of new state and alteration of areas and boundaries or name are not to be considered as the amendments of the Constitution under Article 368. Okay, under Article 368. Okay, it means that the such laws can be passed by a simple majority and by a ordinary legislative process. Okay, so please understand this very important. So Constitution of India and Article 4 declares what it declares, that laws made for permission or establishment of new states. Article 2. Okay, so whatever laws we are making for the admission or establishment of new states. Okay, suppose for example, suppose India is having right now 28 states. We want to admit a new state. Okay, from foreign treaty. Okay, so that will be the 29. So for that matter we need to make a law. So that law will not be considered the Constitutional Amendment Act. Okay, it will be a simple majority, by simple majority, passed by a simple majority and by ordinary legislation. Okay, now second, formation of new states, alteration of areas. Okay, so formation of new states. So within India, the within existing state, we want to suppose bifurcate a big state and then establish two new or three new states. Okay, and alteration of their boundaries. Okay, or areas or names of existing states. Okay, article under Article 3. So that will be also done by simple majority. Okay, that is what they are trying to say. The Article 3 and not to be considered as the amendments of the Constitution. Okay, under Article 368. Okay, so that is the clear thing. So under Article 2, what you are doing, you are admitting a new state. You are trying to build a new state by acquiring by acquiring, let's say, foreign territory, or purchasing foreign territory. Okay, so that is under Article 2. And then you have Article 3. You are trying to alter the existing state's boundaries, name of the state, or making any new state within the existing states. Okay, from the existing state. So Article 4 declares that on in both of these cases, this shall not be this shall not be, this can be done by a simple majority and by an ordinary legislation process. Okay, not through Constitution Amendment Act under Article 368. Now, additional information. Let us see articles related to the Union and its territory. So, Article 1 says that India, that is Bharat, shall be the Union of States. Shall be Union of States. India, that is Bharat. Okay. So, India has two names. The state and the territories thereof shall be as specified in the first schedule. So, whatever states and territories we have as part of India, it's specified in the first schedule. Now, territory of India shall compromise. Okay, so territory of India will have territories of all the states. Union territories are specified in the first schedule, and such other territories as may be acquired. Okay, you have states, you have UTs, and other territories as may be required. Okay, Article 2, Parliament may by law admit into the Union or establish new states on such term and conditions as it thinks fit. Article 4, any law referred to in, so we have discussed this very comprehensively. No such law as of aforesaid shall be deemed to be an amendment of the Constitution for the purpose of Article 368. Okay, now just two more questions. Okay, I think this so far this has been a wonderful discussion. Question number 9. Consider the following countries. Okay, the Citizenship Amendment Act CAA 2019 provides citizenship to people from which of the above countries. Okay, so which of the above countries the citizenship can be acquired? Okay, so you have Afghanistan. Yes, Hindu is in their minorities, so they can acquire the citizenship. Pakistan. Yes. Bangladesh. Yes. Sri Lanka. I don't know. So as per the answer they have given here, let us see the Citizenship Amendment Act, which is basically CAA. 2019 amends the Citizenship Amendment Act 1955 so as to grant a certain class of illegal migrants a path to Indian citizenship. The CAA makes illegal migrants eligible for citizenship if they belong to Hindu, Sikh, okay, belong to Hindu, Sikh, Buddhist, Jain, Parsi, or Christian community. Uh, so Muslim are not there if they belong to Hindu, Sikh, Buddhist, Jain, Parsi, or Christian community, and also are from Afghanistan, Bangladesh, or Pakistan. It does not include Sri Lanka. So option A is correct. Originally, the CAA applied only to migrants who entered India on or before 31st December 2014, with certain areas in Northeast exempted. Okay, under the Ministry of Home Affairs. Just a second. Under the Ministry of Home Affairs, Order Immigration and Foreigners Act. Foreigners Act 2025 eligible migrants who enter on or before 31st December 2025 can legally stay in India without passports or visas. Exemptions exist for registered Sri Lankan Tamils by 9 Jan 2015, Nepalese and Bhutanese citizens, armed forces personnel and families, and registered Tibetans. These provisions particularly relief for Hindus from Pakistan who migrated after 2014. Now, additional information: the Citizenship Amendment Act 2019 recently in news. Recently, the Home Ministry has amended a provision of the rules of the Citizenship Amendment Act 2019 that required applicants seeking citizenship to submit a document by any government authority in Afghanistan, Bangladesh, or Pakistan establishing their roots in these countries. About CA 2019 amended the Citizenship Act 1955 by excluding these groups from being treated as illegal migrants, reducing the residency requirement for citizenship from 11 years to 5 years. This law exempts the tribal areas of Assam, exempts tribal areas of Assam, Meghalaya, Mizoram, Tripura as included in the sixth schedule. Okay, sixth schedule of the constitution, including the tribal areas of Karbi Anglong in Assam, Garo Hills in Meghalaya, Chakma district in Mizoram, and the tribal areas in district in Tripura. Recent amendment: the Union Ministry of Home Affairs (MHA) has amended the Citizenship Amendment Act 2019 rules relating to the documents required to prove ancestral rules roots in Afghanistan, Bangladesh, or Pakistan. Earlier requirement: applicants had to furnish one of nine documents issued by government authorities in Afghanistan, Bangladesh, or Pakistan. These documents were necessary to establish that the applicant or their sister were nationals of these countries. New relaxations are as follow: wider document scope. Applicant can now submit any document issued by Indian state, central government, or a judicial quasi judicial authority that is and records judicial order as proof of roots. Flexibility: the inclusion of etc. gives officials discretion to accept other relevant document if necessary. Religious certificates verifying the applicant's faith can also be issued by local priest or recognized community institution. The Ministry of Home Affairs clarified that the CA is intended to be a facilitative law designed to ease the process of granting citizenship. Officials have been instructed to interpret the rules in the spirit of the law, then enforcing them rigidly. The amendment makes it easier for CA applicants to prove ancestry by allowing Indian government documents, not just foreign ones, mainly benefiting migrants from Bangladesh in states like West Bengal. Consider the so this is the last question. Consider the following: protection of life and personal liberty. Which of the following fundamental rights are available to both citizens and foreigners? Okay, so equality before law, yes, this is for both. Provision of discrimination on grounds of religion, no, this is not. Article 15, it is also only available to the citizen of India. So 4 is incorrect. So whatever options containing 4, we will remove them. Okay, so this is not correct. This is also not correct. Now you see 1, 3 are common. Let now it means that 1 and 3 are correct. So 2 we need to check. Okay. So let us see the option number 2. Freedom of speech and expression. Freedom of speech and expression. No, it can be curtailed because you are if you are foreigner then what you cannot speak anything against anyone. Okay, so that is thing. So you are having limited speech of freedom of speech of expression. Okay, so B is the correct answer. Okay, protection of life and liberty, yes, it is provided to both. Okay, and equality before law. Okay, so article, let us see the explanation. Okay, this is one of the important question. Article 21 assert that no person shall be deprived of their life except according to policy established by law. This means that every individual has the right to live. Their life cannot be taken away except in accordance with the prescribed legal procedures. Okay, the right to life encompasses various aspects, including the right to live with dignity, right to livelihood, and right to have a healthy environment. Article 21 also protects the personal liberty of individual. It states that no person shall be deprived of their personal liberty except according to a procedure established by law. Personal liberty includes the freedom to move freely, the freedom to choose one's place of residence, the freedom to engage in any lawful occupation or profession. This right is available to both citizens and non-citizen foreigners. So, statement one is correct. Freedom of speech and expression is from Article 19. Article 19. Okay, it implies that every citizen has the right to express his or her views, opinions, beliefs, and convictions freely by word of mouth, writing, printing, picturing, or in any other manner. The state can impose restriction or reasonable restriction on the exercise of the freedom of speech and expression on the grounds of sovereignty and integrity of India, security of state, friendly relations with the foreign states, public order, decency or morality, contempt of court, defamation, and incitement to an offense. The protection of six rights regarding freedom of speech and expression, assembly, association, movement, residence, profession, can be available only to citizens and not to foreigners. So two is incorrect. So let us summarize once again. The state can impose reasonable restrictions on exercise of freedom of speech and expression on the grounds of sovereignty and integrity of India, security of state, then friendly relations with the foreign states, then public order, then decency or morality, contempt of court, then you have defamation, incitement to an offense. Okay, it implies every citizen has the right his or her views, opinion, beliefs, and conviction freely by word of mouth, writing, painting, picturing, or any other manner. Protection of six rights. Okay, we have done. Now, Article 14 says that the state shall not deny to any person equality before law or equal protection of laws in the territory of India. This provision confers right to all on all persons, whether citizens or foreigners. Moreover, the word person includes legal persons, that is statutory corporations, companies, registered society, or any other type of legal person. So statement 3 is correct. Okay, I hope that the this explanation is here. Oh my god. So one more page. Oh, sorry for the long discussion. Okay, it's just 2 minutes more. Okay, now Article 15. What is Article 15? So Article 15 protects the citizens against various forms of discrimination based on religion and gender. The Constitution of India guarantees the various rights to its citizens, including no discrimination. Oh, sorry. On the grounds of on the account of religion, race, caste, sex, or place of birth. Okay, it means that no person should be discriminated against on the basis of religion from accessing any public place or office by the state or group. These fundamentals are available only to the citizens. Okay, so again, these are available only to the citizens. Now, additional information: fundamental rights of citizens and for recently, the Supreme Court declined to halt the deportation of illegal Rohingya Muslim migrants from Delhi, emphasizing that the right to reside in India is exclusive to citizens. Okay, the court acknowledged security concerns raised by the government, referring to a prior ruling on deportation from Assam and Jammu and Kashmir. About the fundamental rights are enshrined in Part 3 of the Constitution from Article 12 to 35. In this regard, the framers of the Constitution derived inspiration from the Constitution of India, USA, Bill of Rights. The fundamental rights are granted by the Constitution. Some of them are available only to the citizen, while others are available to all persons, whether citizen, foreign, or legal person like corporation or companies. Fundamental rights available only to the citizens, not foreign. Okay, only to Article 15. You have provision of discrimination on grounds of religion, race, caste, sex, or place of birth. Then Article 16, equality of opportunity in matters of public employment. Article 19, freedom of six rights regarding freedom of speech and expression, assembly, association, movement, residence, and profession. Article 29, protection of language, script, and culture of minorities. Right of minority to establish and administer education institution. Now, fundamental rights which are available to both. Let us look at those. Okay. Yes. I don't know why it is not. So my actually there is just some lag. Yes, now it is okay. So Article 14. So equality for law and equal protection of law. So these are available to all. Protection in respect of conviction of offences, protection of life and personal liberty, right to elementary education, right against arrest and detention in certain cases, protection of traffic in human beings and forced labor, protection of prohibition of employment of children in factories, freedom of conscience and free profession, practice and propagation of religion. Article 25, freedom to manage religious affairs, freedom from payment of taxes for promotion of any religion, freedom from attending religious instruction or worship in certain education institution. Okay, so that's all for today's. I hope that it was very comprehensive discussion and very informative as well. Lots of things we got to know today. Okay, which is basically going to be helpful in the examination as well. Okay, now you see it seems a very easy task to discuss all these things now, because we have already did a discussion of 1 hour. Okay, so that is why it looks now very, very, easy. Now, thank you very much. We'll meet again in the next video where we will be taking the discussion from the question number 11. Okay, thank you so much.